This is Concrete Numbers, where construction meets accounting, tax, and business strategy. I'm your host, George Kazarian. If you're ready to scale your construction business and master your finances, this is the podcast for you.
Hey everyone, George here. So today I want to talk about the FWPA, the Freelance Workers Protection Act, which seems to be getting a lot of attention this year and also has some confusion as well. So I want to talk about how this applies to your construction business, who it applies to, and how to stay compliant. So the FWPA was passed in 2024 and made effective for January 1, 2025, and applies to freelance professionals. Think gig workers, people who work marketing, virtual assistants, bookkeeping, this type of thing, graphic art, photographers, editors, writers, and basically requires that any one of these people that you hire and pay more than $250 to in 2025 and going forward, at least $250 at least within a span of 120 days, that you need to have a written agreement with them. So the written agreement could be on paper, it could be electronic, that doesn't really matter. But the agreement needs to contain four main things. And I'm going to put that down here in the left corner. So the first thing, it needs to contain the names and addresses of both parties, the itemized list of services, their rate or value, and how the payment is calculated, the payment due date, or how the due date will be determined, and also it needs the deadline for the freelancer to submit their invoice. So, as long as it has these four things, then you should be fine. You need to keep this contract on record per the statute for 4 years at least. So once the work is done, don't go throwing it away or anything. If the agreement is silent as to the payment due date, then the implication is that the invoice is due within 30 days of being invoiced. Now, how this applies to your construction business, please note it's only applicable to freelancer professionals that are more non-physical. If you have subcontractors, all them, that does not apply here at all. That is governed by the Contractors State Licensing Board, and this statute does not cover them whatsoever. Also, one key consideration is that this does not intermingle with ABC tests at all. It has no bearing on employee versus contractor classification, with the ABC test, which we'll do another episode on. So again, in 2025 and going forward, if you hired any bookkeepers, marketing professionals, consultants, editors, writers, photographers, anything of this sort, make sure you have an agreement on file. It just can't be only word of mouth. It can't be only an invoice. It needs to be an actual proposal, engagement letter, what have you, that both of you sign, that has both your names and addresses, has the payment, the rate, the due date, and the services to be performed, all that. And if you haven't done it till now, just make sure you get it going forward. These are one of those things you don't want to, if you get into it with a consultant or vendor or whoever, you don't want it to become an issue later down the line for you. Again, it does not apply to your subcontractors at all. Anything in the trades would be subject to the CSLB. So as a best practice right now, it might be worth taking a step back, like assessing, like identifying who that you work with that this could be subject to, get a basic contract going, make sure you're paying them on time, and pretty much you're good there. So it may be worth stepping back and assessing at this point, who you have that could be that this could be applicable to that you work with. Make sure you get a contract with them going. Make sure you keep that contract for 4 years and make sure you're paying them on time. And that's pretty much all it takes to stay compliant. This is a pretty easy one. Now, in terms of, non-compliance, if, you had an issue with the vendor or whatever, God forbid they took you to small claims court. So what could they do? So here, I'm going to put the penalties or, liability exposure down here in the left. So let's go over that. So refusal to provide a written contract when required the freelancer may require an unpaid amount plus an additional $1,000 penalty. Okay. Failure to make timely payment. The freelancer may require twice the amount at the time payment was due. Okay. Other violations of the FWPA. Damages equal to the value of the contract or the value of the work performed, whichever is greater. Okay, so you already see the law, whose side they're taking, just based on that. They're going to give you the greater of the contractor value or the value of the work, And then attorney's fees, court costs, injunctive relief, like if they win, you pretty much owe them attorney fees. And that's pretty much it. Just get a contract with these people. Make sure that it's written, signed by the both of you. You pay them on time, keep it for 4 years, and you're good. So that's a pretty easy one. So, thanks for checking in. If you found this helpful, hit like, subscribe, turn on notifications, and we'll see you in the next one.